Started. So to our audience, good afternoon. My name is Marlene Biener. I am Senior Counsel at the Association of Prosecuting Attorneys. APA is a national nonprofit located in Washington, D.C. We serve prosecutors as well as their law enforcement and community partners. This webinar is hosted in partnership with the National Legal Aid and Defender Association and the National Center for State Courts, and it's made possible by the support of the MacArthur Foundation Safety and Justice Challenge. Thank you so much for joining our webinar today. Today's webinar on innovative practices and policies to reduce criminal case backlogs will be moderated by Brian Ostrom, Principal Research Consultant from the National Center for State Courts. This webinar will be presented by Spencer Merriweather III, District Attorney of Charlotte-Mecklenburg, Keir Bradford-Grey, Chief Defender of Philadelphia, the Honorable Mary E. Triggiano, Chief Judge in Milwaukee County, and Holly Szablewski, District Court Administrator in Milwaukee County. These panelists will share their experiences and their expertise in managing their backlogs during the pandemic. This includes policy shifts, use of bail advocates, and proceeding with jury trials during this unprecedented time. During today's webinar, you will be able to submit questions for our speakers using the question box on the GoToWebinar toolbar that's located on the right side of your screen. You are invited to ask questions during the course of the presentation, and we'll reserve time at the end of the presentation to answer questions. And if you need any additional assistance, please feel free to contact us directly through the GoToWebinar portal or at webinars@apainc.org. So to our panelists, thank you so much for presenting for us today, for providing us with your insights and your experiences and expertise. Brian, thank you so much for moderating, and I'll now turn it over to you.
Thank you, Marlene. A pleasure to be here today. I want to give my own thanks to the members of the panel today. Looking forward to this. As Marlene mentioned, I'm Brian Ostrom. I'm with the National Center for State Courts in Williamsburg, Virginia. I'd like to start out by asking each of the panelists to introduce themselves. So could we start with you, Mr. Merriweather?
Absolutely. I am Spencer Merriweather. I am the elected district attorney of Mecklenburg County, North Carolina, the county seat being Charlotte. It's good to be with you today.
Thank you. Ms. Bradford-Grey?
Good afternoon. My name is Keir Bradford-Grey. I am currently the Chief Defender for the Defender Association of Philadelphia. Thank you for having me.
Thank you. Judge Triggiano?
Sure. Good afternoon, everyone. Happy to be here. I'm the Chief Judge here in Milwaukee County, state of Wisconsin.
Thank you. And Ms. Szablewski.
Hi, Holly Szablewski. I'm the District Court Administrator for the 1st Judicial District, which is Milwaukee County. Thank you for having us.
Thanks. And the way we're going to run this today is we will have essentially 3 short presentations. We're going to start with Mr. Merriweather on the prosecutor's view. We will then turn to Ms. Bradford-Grey, and then we'll come back at the end for the court perspective from Judge Triggiano and Ms. Szablewski. So we'll kick this off here. Let me ask you a question, Mr. Merriweather, to get us underway here. At what point during the pandemic did you realize you were going to have to make a significant shift in policy in your office, and why was that?
Well, you have as your first slide here a cow on top of a barn, and I'll consider myself being the proverbial cow in this circumstance. I'm originally from the Gulf Coast of Alabama, and the only natural disasters that I was familiar with tended to be hurricanes and floods. And that was an important imagery for me because I recognized that the only thing that I could really compare the first 2 months of our, quite frankly, shutdown as a result of the pandemic was a natural disaster. It's the only time when you have critical functions of a society or of a community that completely shut down, and the next stage that follows is rebuilding. But the interesting thing about this was in every single jurisdiction in my state, in every single jurisdiction across the country, and for that matter, across the world, critical functions like court systems were shutting down. The next thing that comes is the flood of cases that come back our way as a result of this sort of shutdown. Haven't seen anything like it. So it was probably about 2 months in that I recognized that whatever our system looked like in March 2020 whatever our case inventories looked like in March 2020, we were going to be in a vastly different world whenever we found our way ebbing out of this pandemic. We haven't even gotten there yet, but we knew that the work of beginning to think about how we climb out of this had to start now. With that, I guess I'll move to the first slide. Right at the same time that we knew that this pandemic was really wreaking havoc on the way that our court system functioned, we also knew that there was a great spike in violent crime in our community, not just in Charlotte, but also across the country. We knew that there was a lot at stake for us, that we needed to make sure that we were doing what we can to maintain community confidence in our court system to be able to mete out accountability and be fair and just. We had to be thoughtful, as all of you have been, about what our jail population looked like. And that meant really taking the time to ask yourself critical questions about how you could make best use of your court system. There's no question that there's a community consensus around who are the people that your community most wants to make sure aren't on the street. We know that for all of the folks who've been trial attorneys and particularly trial prosecutors, that when you're picking a jury, we know the cases that make people understand exactly why it is that they're sitting in the seats that they're sitting in, and those types of cases that make people sort of roll their eyes about as to why we're spending a given amount of time trying a case in front of them. So we know that violent crime cases are the ones that really people understand why it is that they're there and why they're needed. We also know that the older these cases get, that witnesses start to go away, that memories start to fade, and that the more that we have cases sitting on a shelf getting old, they are getting weaker and they are becoming increasingly untriable. And that frankly means that we're not in a position to hold people accountable. When you get to answering all of those things and figuring out how you focus on violent crime, the next stage is saying, how can you change the way you allocate resources to meet the need, what that community consensus is telling you. Let's go to the next slide. So as we restarted, we were thinking about how can we use our existing resources to, make sure that we're addressing violent crime in a better way. Again, that question of community confidence was important because we needed to say, how can we lessen the amount of time that crime victims are waiting on responses from us? How can we be increasingly responsive at a time where our resources are all the heavier? Also, we know that outside of shootings, robberies, rapes, and murders, there are other things that people really care about, like the fact that their homes are getting broken into, the fact that identity theft and elder abuse is on the rise, and we needed to make sure that we could figure out ways to prioritize those cases as well, even in this new world where our case backlogs were prospectively going to be so much exponentially higher. Next slide. We have traditionally thought about drug cases, narcotics prosecution as something that was meant to stem the tide of violence. The idea went that violence follows the drug trade, so we need to make sure that we are devoting some resources to, very sort of low-level drug prosecutions. We had to rethink that. We basically arrived at the conclusion that the best way for us to stop the violence and to prosecute violent cases was to prosecute violent cases. Now, we also had to understand and know that there's still some drug activity, namely true sales, not middleman who is sort of caught, who himself has a substance use disorder and is sort of selling to maintain a habit, but the people who are selling, and the selling turns into a robbery, who are actually, running a garden variety crime syndicate right on a corner. That's the stuff that we needed to be concentrating on. That's the type of drug activity that we needed to be thinking about, not the stuff that involved petty amounts of a whole bunch of controlled substances on the street. Those were cases that ended up usually taking the most amount of time to get to court. And when they got to court, they were old And then when we got to court, our jurors were looking at us and wondering why it was that we were trying those cases, knowing that they're looking at the news every day and seeing that people are getting killed and seeing that people are getting robbed and seeing that very serious violent crimes are happening. And they wanted to know why it was we were prioritizing those cases. So we had to make sure that we devised a way of thinking seriously and more focused and more tailored about the way that we approach drug prosecution. Next slide.
That's an interesting perspective. I was wondering, what did you have to do to convince other community stakeholders that this was the right approach and policy?
Well, certainly for law enforcement, I think there was and still continues to be, a case that has to be made to them as to why, reducing or quite frankly eliminating our simple possession prosecution cases was the way to go. And so we had to show them that enabled us to increase the number of prosecutors in our office that were dedicated towards the prosecution of violent crime by 50%, just by taking those simple possession cases off the chart. That we still were allowed, put in a position to be able to proceed on sales and trafficking cases, that we were now in a better position to proceed on residential breaking and entering cases, that we were in a better place to be responsive to victims and frankly responsive to law enforcement, merely by not addressing these other cases that were taking 3 years to get to trial anyway. Now, what we found is that a lot of times your on the ground patrol officers, it was such a change in perspective that there was a lot more resistance. But when we started to go up the command structure, when we started talking to police sergeants and divisions, when you started talking to police captains, when you started talking to police chiefs and police captains who were looking at their homicide numbers that are spiking, who are looking at the fact that there are dangerous people who are roaming those streets, and that the timeliness of dealing with those cases was extremely important. I believe they realized that certainly in this climate that's the tact we had to take. The features of our specific plan I'll go through really quickly. First, once those cases come in the door, officers are free to still make those arrests and make those interventions where they need to, but we immediately try to deflect those possession cases into social service agencies. We're talking about recovery agencies, we're talking about hospital systems, we're talking about peer support, and that's without a lot of screening from us. So that meant we weren't really giving hard looks and diverting folks and holding on to cases while people went into recovery courts. We decided to try to refocus our recovery courts on the type of criminal behavior that we knew substance use disorder was behind it. So a person still had the opportunity to potentially get their case diverted and dismissed through recovery court, but only after we were able to, in speaking with defense counsel or even looking at the underlying facts of the case and see that substance use was behind this. We also were able to use recovery court as a way of focusing on those offenders who had multiple levels of engagement with law enforcement through drug use within a year. Because what we also found is that for a lot of our drug possession cases, these weren't people who necessarily had, a documented substance use disorder diagnosis. A lot of times these were people who were engaged in recreational use. And that may be a bad thing. I think that's for other folks to decide. But what a person in my position is charged with determining is when we know that our case backlog has exploded, when we know that we have a rising violent crime problem, is recreational drug use really the best use of the very limited resources that I've got? And the answer to that for us was no. Go to the next slide. As I mentioned, our expected results here are that I know that because of how we were able to reconfigure our prosecution teams, we were able to dedicate 50% more prosecutors to the trial of violent crimes. Some people may say, well, why don't you just change your offers in some of those lower level cases? What we found, and I think what any prosecutor has found over the course of time, is that just changing offers, especially in this climate, doesn't necessarily allow you to control what your case flow is. Because that means that only the advice of counsel, defense counsel, is what's controlling your case flow. Whereas as the prosecutor in deciding what sort of cases I'm actually letting into the court system at all, meaning that I'm asserting that level of control over what ends up in front of juries at 12. I've talked about the fact that we've changed the calculation as to how drug cases are to be contemplated in terms of violence, that we thought we could be more narrowly tailored in that regard, and we have been. What was really important for us as we engaged with law enforcement and other stakeholders was to remind people that, look, I'm talking about how it is that I'm going to use prosecution resources. As far as what actually happens on the street and what sort of interventions might need to be taken to stop someone from in the midst of criminal behavior, that's a different deal, and that's, quite frankly, within the purview of law enforcement. I know that separates me from a lot of other people who have employed different strategies with regard to low-level drug enforcement, but that's just where I landed, that I had to concentrate on what I thought was within my purview as a prosecutor who has very limited prosecution resources at its disposal. I also want to say that my community also understands that this decision that I've made is not about my own personal opinions about the value of drug enforcement. It's really about how it is that I've decided to use resources in my office. Next slide. The final thing I'll say is that people will ask you and say, well, under this policy, haven't you just legalized drugs? For me, the answer is no. I have changed the way that we've looked at drug prosecution and changed the way we've carried it out, but we haven't. I haven't changed statutes. That's the purview of the legislature, and I want to make sure that I'm, giving our General Assembly space to handle that as they see fit. But they have given me a constitutional obligation to try to use resources as best I can. The second thing I'll say is, and I'll wrap it up, the handoff to social services is hard. It's one of those things that everybody talks about, but actually carrying it out is really, really difficult, especially when you're not holding on to those cases, which really is a use of labor, prosecution labor. So we're already in the midst of more expansive outreach than we've ever done before as a system. I have borrowed much of this model from Jeff Rosen from the Santa Clara, California prosecutor's office. And one of the things he said is that the resources that we have are best used in trying to secure public safety. And everyone across the world at this point has identified this as a public health problem. So we need to make sure that we're bringing the public health people into the conversation on this. And quite frankly, a lot of it's getting out of the way. So for me, the last 60 days has been about outreach to those folks. I know that we're not looking at a 60-day conversation, but probably a 6-year conversation in establishing many of those things. I'm going to kind of talk about Jeff one last time before I turn it over to questions, and say that Jeff Rosen's office says that in their first year of implementing a program like this, they were able to reduce drug prosecution by 90%. I thought he was crazy when I first heard that he employed something like this. And then he said that the whole reason that he did it, this was pre-pandemic, was because his violent crime problem was through the charts and he needed to free up resources to deal with violent crime. In the year of 2020, that's exactly where I am as a prosecutor. That's exactly where prosecutors all across the country are with the spike in violent crime. So I think it's an invitation to consider something exactly like what we've implemented here and what's been implemented in Santa Clara County. And with that, I'll certainly take whatever questions that you have.
Well, yeah, thank you very much, Spencer. It was fascinating. I'd like to suggest that we hold on to our questions to the end. Just as a reminder, we do have question box here that people in the audience can type in, and we will get to those questions at the end. Thanks again. So let's turn to public defender perspective. Keir, we know that COVID-19 has turned everything upside down, and it's a very crazy situation. How did public defenders in Philadelphia respond to the crisis in order to best protect your clients?
Well, thank you so much for that question, and thank you for inviting me to this panel. I was really happy to hear what District Attorney Merriweather was talking about, because that's exactly what we've employed here in Philadelphia. And I can say that our employment of our social service advocacy to deal with quality of life types of issues, challenges that we know were not going away by prosecuting them in the justice system, because people with social needs need a social response for the most part, because when we had low-level drug use, and I say low-level drug use meaning they're not dealers, because some dealers do use as well, we knew that people would come back and forth 5, 6, 7 times in the system and it wasn't a deterrent. So 2 years prior to COVID, we had started to create what we call our pre-entry initiative. And this is where right out the back, when people were arrested with lower level offenses, we would find a social response to present to our courts and our system and our district attorney for an alternative way to deal with these cases. Not that we didn't have diversions, we did. Our diversions were full, and our diversions sometimes are very limiting based on a person's background and history. So we wanted to create kind of this informal diversion process that would allow us to use these untapped resources in our communities, and that really understood not just the person, but the communities that came from, the gaps and the triggers, and they would actually work to help. I say this pre-entry coalition because, like District Attorney Merriweather said, it is hard to just do this warm handoff with nothing else. So we actually created a whole process by which we were able to work with many service providers, many just program providers in the communities, establish a consistent communication between our office and them, and then continue on looking at progress so that when the case came up, we could give it to the district attorney for a determination as to whether or not this person actually needed a lifetime conviction, because in Pennsylvania, a conviction, even of a misdemeanor, is for life. Or could the case be withdrawn based upon the fact that this person has been engaged and supported with things that actually have helped them progress. So we really called and relied on this when COVID came, because now was the opportunity to really focus our justice resources on the things that really rid our city of public safety, and not overload it with all of these other cases that we were dealing with, where we really couldn't get to the main things that the public was concerned about, and those were the violent crimes. You can go to the first slide. And you know, some of our conversations are going to be similar, so I don't want to overlap it, so I'll skip through some things, but I do want to talk about the process that we engage, because the process, you know, there's definitely the policy, but the process is always hard to understand. So we pretty much charted out everything we did. On March 6th in PA, there was a declaration that it was an emergency, but we still didn't close our courts until maybe a week and a half later. And at that time, there was no real understanding of what to do. Everyone started going into a frenzy. So defenders did something that was really unconventional for defenders. They started to look at their cases and their clients, and we had to actually pick and choose who would be a safer bet to see if we could get released on an emergency release petition, so that it didn't rise a spike in violence and crime, because we know that would only cause a regressive policy making by our city, our courts, and our district attorney. So we wanted to make sure that we were careful. We knew that this was going to be a situation. Of course, we didn't realize we'd be here for a year, but we knew that this was going to be a situation we were going to be in for at least a little while, and it was going to cause us to have to consider who we were able to advocate for, that they should be released, and work with our community partners through our pre-entry coalition to make sure that they could handle the people and the types of challenges that they faced. So we began to file motions to individual judges, because we hadn't really coordinated how we were going to do this. And individual judges were getting all these motions from our office, and we had to figure out and work with our courts on how do we streamline this. So our courts then designated certain judges to hear these emergency petitions. And these were judges that understood the goals. So it wasn't just your individual discretion. It was, look, if there's a goal here and there was a presentation of a plan, and that plan was going to be further followed up by the Department of Public Health, because we employed them as well. They were a critical part of this, because as we hand off, we don't have case management capabilities. And they provided those case management capabilities, while we worked with the program providers on communicating, is the person going? Are they doing well? Do we need to pivot to something else and find a different program because this person needs more supports? That was critical, because that communication channel that we have created 2 years prior allowed us to stay vigilant on what was going on and how we can present cases even before they came back up to the district attorney saying, hey, it's been 9 months. This person has been fascinating in this program. Can we withdraw? And I'll get to that a little later, but that is what actually ended up happening the longer we were in here. And so this is just kind of a map out of what we did in terms of in the emergency stage. And on June 1, we stopped the emergency stage and more judges started to come back into the courts where we were able to then go into these particular rooms and have hearings then. You can go to the next slide, please. So, we wanted to just document everything we've done because we wanted to make sure we understood the work that was generated by our office for a lot of reasons, especially resource reasons. Many of our funders were faced with a huge, enormous problem of having a shortage of money flowing into our cities and counties. And so everyone was looking at budget cuts. So this is just for the defenders out there who know budget is something serious that we constantly have to fight for. We don't get the automatic valuation for our services. So we wanted to make sure they knew how much work had been done by our office, even while we were shut down. You can go and what the savings was, because when we released people on a plan, of course, they weren't just sitting in jail racking up the dollars that it cost every day. So we wanted to make sure that they knew how much good stewards of the public's tax-paying dollars we were being. You can go to the next slide. And of course, these are all the people that we worked with, and this is the things that we worked with. Of course, housing instability, substance abuse, mental health. These were our partners. These programs were in our pre-entry coalition already, but there were other unconventional types of programs, right? There was the Fathers Initiative, and these are people that were peers for young fathers and just men who needed just help and support and someone to call for mentorship. There was the Women's Initiative. So some of them weren't your typical, in our pre-entry coalition meeting, they weren't your typical substance abuse, housing, or mental health. They were the whole gamut of people who were just there to provide hands-on support through very difficult times. And they were able to connect with us if someone was going through an episode or struggling with some kind of crisis where they were using drugs or their mental health issues were being exacerbated. You move to the next slide. One of the things we thought was important is to look at the recidivism rate. And we wanted to make sure that what we were doing was actually effective. And this may not seem like it was that effective because we do have some recidivism, but nothing is 100% proof, right? Nothing, not even the system itself. So we did 9 months in terms of charting all the people that were released and what their total rearrest was versus the 1 year recidivism, which is the standard that people look at once a person goes through the system and has a final disposition, and then they are placed on some kind of probation or whatever that is. And what we had done, because we were so careful and considerate, but also worked with program providers, we had seen that it actually lowered recidivism for those people in the 9 months. Now, this was back in, this was done in January, so we hadn't updated anything for March. But what we had seen in terms of the recidivism rate is that it wasn't exponential. It didn't rise higher because we were, releasing a lot of people in a short period of time from prison. In fact, it was lower and it stayed steady given whatever we're going to find out for this last 3 months. But there wasn't no apocalypse because what we were doing was clearing out the prisons a little bit more so that it could allow for more social distancing and better targeting of our resources. So that was where what we found was very helpful in talking to our stakeholders and talking to just other people that were concerned about the amount of people that were being released from jail, that we wanted to make sure that we tracked who came back in. And so when we look at total rearrest, a lot of the 23% was for drug use. And in our police department, they made a decision that they were going to begin arresting people for possession of drugs again. So that was for drug use. There was a 3.7 in violent rearrest, and that's not talking about just homicides. That's anything. That's assaults. Things that would be ordinarily considered a crime of violence. We put into the violent rearrest. We can go to the next slide. And Brian, please tell me what my time is because sometimes we're looking at these slides and they can be pretty extensive. We also wanted to make sure we were tracking our backlog, because as we started to track our backlog, we had to make sure that we told the stakeholders where we were going to end up. Even when we came out of COVID, we were going to be looking at almost a year's worth of inventory on top of the new cases that were being generated. And so we had to make some tough decisions, because even if we started to open up and do business as usual, we couldn't get through the amount of cases that we had to deal with by not being more creative. And so I think District Attorney Merriweather said they had to prioritize what they were going to deal with. And really, we found like this is a great opportunity to start to really restructure and envision a new justice system that makes sure that it does what's necessary and not what's not. So when people have social issues that may need a social response, that we had a mechanism for that. It can be brought further to scale, and I'm not saying that it's finished, but it at least has started to put us on the path to understand how to operationalize this idea that if people do have things that they come in contact with the police for, police can themselves divert. And we are bringing these partners into our courts, bringing them to our stakeholders so that they know this exists. And we actually have it in a partnership mechanism with the Pre-Entry Coalition. So everyone's names, their organizations, their contact liaison is readily available for whomever would like to access it. You can go to the next slide. So it's a little busy, but you want to, so if I have to stop, we'll stop, because this is definitely.
So I just wanted to ask you a quick question with the, with all that growing backlog, and with, of course, your first priority being attending to your clients' needs, is how are public defenders, were you able to deal both with the backlog and with ensuring protecting rights of your clients? And also, it's about 3 more minutes if you. Okay,
we can stop the PowerPoint because this is kind of getting into another area, but your question is really appreciated. So obviously, we could not attend to every client's needs for due process, right? Because the courts had just shut down. So we couldn't guarantee anyone would have their trial or case heard in a certain period of time. One of the things we did not want to do was start to work in this kind of plea arrangement where people would have to plea to get out of jail, because that would not serve any needs, where we couldn't do our job to duly investigate cases and then have intelligent conversation with them as to whether or not they should take an offer, because the stakes are higher now when COVID is hit. Many of the federal aid programs exclude people with felony convictions within the past 7 years from accessing loans, accessing money. So this is a real collateral consequence issue as well. So we had to really focus on those cases or those people that had the identifiable needs, meaning their charges really spoke volumes to what was going on. Whether this was something of a crime of violence, a criminogenic nature, or was it social? We did that. And so we cleared out everyone that did not have a violent arrest. Now, just because someone has a violent arrest, it's still an arrest. And we were not, unfortunately, able to meet the needs of those people who are still sitting in awaiting very important hearings, such as the probable cause hearing, because we have to dig deeper into the layers of the case to get to what's really going on. And that oftentimes requires us to cross-examine the witness or understand the witnesses, what they're going to testify to. We have somewhat of a small blurb of a police report to begin with, so we really can't get a full understanding of what the case is. But those are the cases where we're still struggling to figure out how to meet the needs and how to get their cases moving. Now, our courts are moving. We're in trials that are not as robust. We're doing jury trials. We're doing some of the violent hearings, hearings for the violent cases. However, they're moving, very slowly, and we're not really able to figure out a resolution because there's things that we just can't do at this moment.
Oh, well, thank you so much. Appreciate that.
Thank you.
So if we could move the slide up to the picture of the courthouse, and then turn to practice in Milwaukee. I was curious if you could, what did the planning process look like for resuming in-person hearings and jury trials for you in Milwaukee?
Sure. So great presentation from our colleagues here on the call. So I would say, and I would go to the next slide, one of the biggest things that the planning process instituted was meetings. But what we knew right away, and I knew is right away, that there was, we had vital relationships that provided really strong cross-sector collaborations to help us create our COVID response playbook. There's no playbook for this. Everyone was sort of making it up as we go along. But we knew that we had to pull those collaborations together to really make and generate new solutions to our problems that we were facing and to keep people safe. And I would say to save lives. And I think we did that by doing everything we could to facilitate a safe recovery. So I'd talk about 4 basic collaborations that we had. One was with our Community Justice Council, which certainly champions our work for the Safety and Justice Challenge, but it also shifted and started to focus on recovery efforts. And those are judges, DAs, public defenders, law enforcement, jail, corrections, our governmental agencies that literally came together daily in the beginning of this pandemic to brainstorm issues so that we could slowly reopen the courts. We also focused on reducing our footprint in the jail and the House of Correction. And just to give you one example of the collaboration, we had a set of district attorneys and public defenders working together based upon criteria set by the judges to see who could be released safely from the jail and the House of Correction, those on the end of their sentence. And then they would provide a list to the DAs for victim notification. And then I would get that list, and based upon an agreement with the judges, I would sign off releasing individuals from the jail and the House of Correction so that we could keep that footprint low, so that we would not have the spread of the virus in that institution. We also worked with the CJC and frontline staff to listen to their needs about reopening and what they needed to do. The second group I would talk about, and I think it's innovative in and of itself, and it was provided by our county leadership with a prioritization to reopen the courts, and we call that the FROG team. That was our facilities reopening work group. County leadership, carpenters, people who measure things, people who do risk analysis on opening the courts. The focus was on reopening the courts, but also using federal COVID dollars for the courts for PPE, as well as technical and Zoom enhancements to our courtrooms. And the third thing they've done now is actually allow the courts to be part of their vaccination process. And so we were slipped right in with them and allowing us to go to a closed pod to do that. I would also say they've added our jurors now to that. If you get a jury summons, you can go to that closed pod weeks before you have to present for jury, get your COVID vaccine so that you can be safer when you come into the courts. The third group was our lawyers in the general community and our bar associations. They provided both committee support in terms of reopening and let us come on town hall meetings so we could get the word out about what we were doing to keep our courts safe. We also, within all of these groups, had public health experts at our disposal and on speed dial, because we wouldn't make a move in reopening without consulting with them, because we knew this was a public health crisis and needed their input. The final committee that I think is really important, it was more general, but it was a focus on what can the community do to help the courts. And for instance, the Milwaukee Public Libraries decided they were going to apply for Zoom dollars or COVID relief dollars to create Zoom rooms in the libraries so that our community could go there and Zoom into the courthouse for access to their court hearings. And so vital relationships were really key for us in all of our pandemic planning. Next slide, Brian, thank you. Largest courthouse in the state, certainly not in the country, but it gives you a general idea of what the Milwaukee County Circuit Court looks like. And we focused mainly on the criminal courts because of their high priority and the need to, again, reduce jail and House of Correction population. Next slide, and I'm going to turn it over to Holly.
Thank you. So the data that I'm going to take a brief walk through with you is data across all of our divisions. This isn't specific to criminal, but certainly the trends that you'll see in the data apply to the criminal division. And this slide, the blue line, depicts what I call the pandemic crash in terms of court events held. So prior to the pandemic hitting us in March, we averaged roughly 5,000 to 6,000 court events each week. And you can see by the blue line that when the pandemic hit us, we dropped to less than 1,000 each week. Next slide, please. When we look at filings, again, you see with the pink line where the pandemic hit us hard. And normally we average about 2,000 to 3,000 new cases coming into our court system each week. That dropped again below 1,000 and hovered around 1,000 for a fairly significant period of time. So that's what the pandemic crash looked like for us. Next slide, please. So how did the state, county, and the courts respond? One of the biggest things that occurred and one of the most helpful things that occurred was the rapid deployment of technology to the courts. The Director of State Courts purchased 500 plus Zoom licenses for judges, court administrators, and other court employees across the state. Milwaukee County purchased laptops and mobile phones so county employed court personnel could work remotely. CCAP, which is the court's information technology and case management arm of the court, established secure remote user access for hundreds of judges, court commissioners, administrators, and other key state employees across the state, 72 counties. Milwaukee County added Zoom integration in every single courtroom using CARES dollars to help improve the Zoom experience and expand the court's ability to reach remote parties and litigants. All of this allowed the courts to move fairly quickly to a virtual environment, which was really critical to trying to stay afloat with a developing backlog. And next slide. That's you, Chief.
That's me. Health and safety mandates. Again, working with our public health experts, we knew that in order for us to stay open and function, that we had to put in risk mitigation factors, which included mandatory masks in courthouse facilities. In fact, the Wisconsin Supreme Court, although they just struck down the statewide mask mandate of the governor, we're pretty focused on having everyone in the courtrooms continue to wear masks, and that's still ongoing. We worked with the FROG team concerning disinfectant protocols. Of course, we had physical distancing, 6 feet or more across the courtrooms, elevators, bathrooms, building entrances, and waiting lines. After a period of time, excuse me, we increased our protocols by asking everyone to do a health screen before they came in, and you could do it on your phone, you could do it on your computer. You have to show a security officer when you come in that you've passed that screen. If you have a red check mark, you can't come in. So we got pretty strict as the number of incidents of COVID spread rose in our community, because we did not want to shut down. We believed we are an essential functioning business, and we wanted to keep people safe, so we didn't shut down. And then we started to do contract tracing. Our public health department was way too overloaded, so we instituted a collaborative effort to do that across the sectors of those within the courthouse. And I knew about every contact, every positive in the courthouse, so that we could keep people safe that way. Next slide. I think we really hit on some of the operational planning, but just real quickly, I would liken it to a play in the theater in terms of how we approached this. Our play, for instance, was we're going to put on a jury trial, right? And we need to keep people safe to do that. So we assembled a team of actors and stagehands. That was via Zoom originally. We had to get a stage design in order. That was our FROG team, who used carpenters to put plexiglass in the courtrooms and who put signs on the ground so that the actors knew where to stand and they couldn't come within 6 feet of the other actor. Then we actually had a dress rehearsal. We put on a mock trial run through, and we actually had 30 persons in a voir dire room and then 14 in the jury box, and a defendant. I think one of the DAs played the defendant. The DA came in and was the defendant, and we looked through every aspect. We had court reporters in there so that they could see if they heard. We did sound checks like they would do in a play. And then we ran through the play in real life. And then, of course, waited for the critics. And our critics were the public health experts who would come in and say, you know what, you got to be careful about this. You got to worry about that. Let's tighten it up. Because we did not want to have spread in our courtrooms, and we wanted to keep our jurors and our employees safe. So we repeated that for different kinds of scenarios, and that seemed to work really well, and everyone was very happy with us doing that. Next slide.
Oh, thanks. I appreciate it. That was a great analogy to the play. Nice way to put it. I was curious if you could say what some of the positive experiences or the challenges that you faced when you were resuming in-person hearings and trying to get jury trials back underway.
So thanks, Brian. I think probably, as the chief mentioned, one of the huge positives was the nature of the cross-system collaboration. I mean, everybody in a system that's very adversarial, people came together, the different stakeholders came together and really supported us and helped vet our plans and provide, input into our plans. I think the other big positive is the system changes that have resulted with especially remote appearances, improving access to justice for individuals who struggled to come to our courthouse. And those changes, some of those changes are likely to stay in place. The technology enhancements are a huge plus. We've always been a bit challenged in that area, and so those are some of the positives. I think some of the roadblocks we encountered involve mostly time constraints and space constraints. Early on in the pandemic, for the first number of months, there just were not enough hours in the day to get the planning work done. At least that's how it felt. We had significant space challenges, especially as it related to voir dire and deliberation for jurors. Some of our space is very, very small, especially for deliberation. And so we had to work very hard to identify alternative spaces and get those set up. I think the other, I would say, challenge is the issue of COVID fatigue. It is very real. I think a lot of court system employees are really reevaluating their life situation and status, especially if you've been in your career for a long time. I think it's been a rough, 13, 14, going on 14 months. And so I think that's been a real challenge in keeping people engaged in what seems like a never-ending battle. So I thank you for that question.
Yeah, I would just add, I believe there's a shadow side to this pandemic that we haven't seen yet. And that's exactly what Holly said. The health and well-being of our workforce is really starting to see it impact us because we don't have the resources to open this court or do this where we want to. And that's human resources. And it's been a struggle. And I think people's mental health has been exacerbated by it. And we really need to pay attention to it.
Mm-hmm.
So I'm just going to go quickly through these next couple of slides. They're really just a look at the work that was done to set up our court facilities to make them safe. So this is just an example of what individuals coming to the courthouse see at the entrance. Next slide. This is a courtroom that's decked out in plexiglass, and our judges learning to pivot very quickly and learn the new Zoom integration technology, which wasn't easy for a lot of our judges. Next slide. There's plexiglass everywhere, right, Chief?
Like I said, my father was a carpenter of 42 years, and it was great watching the carpenters come in and start cutting. You had this all cut, and they put it in. And in the jury box, it looks like you're sitting in a little tube. But the jurors actually were very complimentary of us. They felt safe. They were masked up. Everyone was distanced. They had other safeguards of plexiglass on the side of them. And so messaging out that was important to get enough people to come into the courtroom to do jury trials. Next slide. I know this is more plexiglass. Okay. Next slide. So again, with the help of our public health experts, we continued to take a slow, stepwise approach to reopening. Some people wanted us to open all the courts really fast, and others were like, I don't want to ever come in again, right? So we needed to land somewhere in the middle, and that public health advice was just so invaluable. So phase one, we opened very slowly, 7 non-jury trial courtrooms so that anybody who needed to do an in-person could do an in-person. But the message was Zoom, Zoom, Zoom. Don't come in if you don't have to. We then tested the waters with 2 jury trials. Phase 2, we added more. And then phase 3, which is coming in May, 4 more jury trial courtrooms because our backlog is still, we're struggling with it, especially for those who are incarcerated on speedy trials. And we will continue to do this slow and with a good rhythm so that we keep people safe. Next slide.
So I'll take that. I think due to time constraints, I'll advance to the next slide, please. And go one further. I'm just going to talk a little bit about weekly dispositions because this is where the backlog issue exists, right? So you can see with the pink line what happened to our weekly dispositions, you know, in March of last year. You can see the black line, which is the first, you know, few weeks of this year, that while we're doing better, we aren't where we need to be on case clearance and cleaning up that backlog. We still have a very limited number of courtrooms. We've impaneled jurors in about 73 criminal jury trials since last July. Normally during that period, we would have done 300. So we're still behind the 8 ball. And our dispositions lag as a result of that. And I think our best educated estimate is that it's likely going to take us approximately 2 years to get out from underneath this type of backlog. So with that, Brian, I know time is of the essence here. I'll end there.
Well, thank you so much. That's fascinating. Interesting to hear what has been going on with the challenges and some positive benefits, the positives that has happened in Milwaukee during the pandemic. And sort of following in that vein, we've talked a lot about challenges, but one of the questions we've got from a member of the audience is, how do we encourage system actors to look to sustain COVID-related reforms that better serve people long-term? So we've been part of this giant pilot project, and some of the changes and reforms we've introduced may actually serve people better. And just like if everybody could just give their short reaction to that.
So my short reaction is shame on us if we go up the same way, because what we've realized is how we've impacted people's lives in sort of a negative way by putting up all these policies and ways that they have to jump through hoops to get access to justice. And so we are looking at every division, every piece that we do, and we are trying to work, again, collaboratively to keep in some of the positive attributes of what changed. And I think Holly mentioned some of those, and do away with some old routines that we have that's really impacted people's ability to come and have their day in court.
And if I can add, you know, first of all, everything the judge just said in terms of the systems approach is spot on. We really learned that there are some hearings, and I don't mean adversarial hearings where you have a witness. There are some hearings that can be done more efficiently via video now, and that's just the formality hearings. But I really want to look at in terms of the outcomes that people have been able to achieve when looking at alternatives to help deal with some of the issues that they come into the justice system for. If we start to look at those outcomes and how positive and proactive those outcomes have become for people to be progressive and not use this system as a revolving door, then we should continue to do what works and not what doesn't. And so I'm hoping that we use this as a model and mechanism to learn what do we need to use our justice system practices for, and when do we need to deploy the resources of the system to solve problems.
For the last, however, 50, 60 years, I think while there are a lot of differences between all of our court systems, I think it's true as across the board that our judicial systems have burned mostly on fumes and inertia. And for the one time when you actually don't have inertia to move things forward, it made everybody ask critical questions about what do you really need to do? What do you really, does this make sense? And this examination over the course of the last 13 months has been extremely important because it slowed everybody down. And as opposed to just doing something because it's the way we've been doing it for 40 years, 50 years, we, in a real critical way, at least in my district, we're really asking questions and working through the steps to figure out whether our processes make any sense at all. And where they don't, we're looking for new opportunities to change them. It also makes our resource asks make sense to both federal and state partners.
We have another question for, I think, folks mostly in Milwaukee about with security related to the plexiglass. How secure is the plexiglass? There has been, for this individual, courtroom security has expressed some concerns about the potential for it to be dangerous if used offensively in the courtroom.
Sure.
Yeah.
Holly, go ahead.
Yeah, so that very question came up very early in our kind of planning and walkthroughs in the courts. I think for us, what we did is we included the captain who is in charge of court security right out of the gates. He looks at security from obviously a different perspective than I do. But the one thing we were both on the same page about is if that plexi is going to be at the table where the defendant is seated with their lawyer, it has to be anchored to that table. And so that's what our facilities crews did, is they literally, built wooden slides that then mounted to the table where everything is connected. Initially, there was a thought that we wouldn't have to do that, and it was like, nope, it has to be done. And to my knowledge, there's not been any issues or any attempt to use plexi in any of our jury trial courtrooms or in-person courtrooms as a weapon.
Yeah, I think that's a great question. I think I would just add that most of our hearings are Zoom hearings, especially when you may have someone who might be considered volatile. And so you don't necessarily have to bring them in the courtroom, right? And they don't usually want to be in the courtroom. And we try to facilitate the public defender being with them wherever they are. But Holly's right. When we brought the person in, the Captain Holton, to look at it, it was very helpful in planning our plexiglass placement and how it was going to be placed.
Thank you. So we're getting close. Marlene, do you have any one last question?
Yeah, so we probably have time for just one more question. And something that folks are interested in is whether any policy or procedural decisions have included the voice of communities and people served by the courts.
Yeah, I know for a fact in Philadelphia, like we said, our pre-entry coalition was a huge part of our planning process. We then started to vet what we were doing and what we can do further with our community advisory committee, who really started to talk about what they could tolerate in their neighborhoods and what they would love to be able to have a hand in helping to be part of the solution. So they were huge, because when we're talking about justice system, it's kind of insulated sometimes based on, who the decision maker is. And to bring them in to have not just a voice, but agency in the solution was really huge. And it was a game changer, because we started to really realize the types of things that community wanted and the types of things that community just didn't want in terms of justice system intervention.
I would just add that our Community Justice Council has a variety of subcommittees, and included on those subcommittees are the voices of people with lived experiences and community members, and then they feed the information back up through our executive director of the Community Justice Council. And so we can do better at it, let me tell you, but I think we did hear from them, and they had some pretty good ideas in terms of the Zoom issue and Zoom access, and the fact that there are people out there that don't have phones or bandwidth or minutes or whatever. That then led to the Milwaukee Public Library's project that we've been working on, and so those voices are very helpful.
Milwaukee County's Community Justice Council was sort of the model for some conversations that we started in our jurisdiction to try to create something like it, but we did not have that in place at the time of when the pandemic kicked off, and quite frankly, things were just too emergent to try to create something in the middle of it. But those conversations have resumed, and we're a lot far along. We're trying to mirror what Milwaukee County's done.
Thanks, Spencer.
Thank you.
Wonderful. Thank you also very much. Brian, thank you so much for moderating. Thank you to all of our panelists for that excellent presentation. And thank you again to our webinar audience for attending. If you did have a question and we were not able to get to it, we will be replying to you after this webinar concludes. This webinar was recorded. All of the materials and the recording will be made available at no cost on our APA membership website, and we'll notify you via email when those materials become available and how you can access them through a temporary membership. And if you are a current APA member, you'll have automatic access to webinar materials once they're available online. If you have any additional questions or concerns, please email us at webinars@apainc.org. Once again, thank you for attending and have a nice day. Bye-bye.
Thank you.
Thank you. Thank you,
Nice
Brian.
meeting
Thank
you
you.
guys.
Thank you,
everyone.
Spencer.
Good to meet all you guys. Talk to you soon.
Yeah,
Thank you so much.
Definitely.
Keep up the good work.
Thank you. Me too. Nice meeting you.
Both y'all.
Bye-bye.